Hello, folks. We're going to give a few more minutes for people to join us. We have a pretty good crowd here, but we want to let people take a few more minutes just to join us, and then we will start this. If you guys would stay on mute, we'd appreciate it. And please notice that there is a dashboard where you can mute and also type in your questions. We'll keep the attendees on mute, and we will only have the presenter or myself speaking today. Okay, it's a couple minutes past the hour. I think I'll go ahead and get started. I'm Cynthia Stewart, and this is the Business Performance USA weekly webinar. And we're so happy to have all of you here. And there goes my screen. Here we go. We're so happy to have everyone here in the audience today. This is the basic truths about background screening, transforming your business decisions. And I am Cynthia Stewart. As I said earlier, I'll be your host today. Also, what you'll notice is that Business Performance, just so you know, Business Performance USA is actually a voluntary association. You can sign up as a member for nothing. So go on to businessperformanceusa.org and you'll be able to view this webinar in recorded form in the future, as well as all the other webinars that we've recorded to date. So this is a good way for you guys to stay connected and to get information. Today, our presenter is Nancy Lynn Roberts. And as you notice, she is an attorney. There's that Esquire. And I am getting some noise. I hope that that is not my computer, but I hope everyone in the audience will go ahead and mute their computers. That way we won't have audio interference. Let me talk to you a little bit about Nancy Lynn Roberts. First of all, she's a business owner and she is owner of Track One, which is a professional accredited background screening firm. So she is an expert, and you're going to hear very good, wise talk from Nancy today. One of the things that you need to know about her is that she wears many hats. She has 4 children. She's at the same time a chief operations officer for Track One, and also, she really knows about compliance and risk management. So she's the person that can help us out in this area of background screening. She became a business attorney in 1992 and has had very specific and long-term industry experience in a variety of entrepreneurial endeavors. She and her husband own several companies. Healthcare is one of the fields that she's worked in, as well as nonprofit and for-profit. She has had worked in staffing, employment, background screening, and technology. The thing about Nancy is that she really has established a record of reducing or managing risk for both entrepreneurial and established companies. So she's also built from the ground up comprehensive compliance programs and processes for large multi-corporate systems and small businesses alike. She is a passionate advocate for improved compliance and professional certification and accreditation in the consumer reporting industry. And she is a very active leader of the National Association for Professional Background Screeners since 2006. Currently, she's the chair of the Background Screening Credentialing Council that oversees the National Accreditation Program for NAPBS. Say that 5 times. So, Nancy, we welcome you. We're so excited to hear from you about this topic, and we know everyone is looking forward to hearing what you have to say. Folks, we want to make sure this time is well worth it for you. You can use, there's either a chat feature or a question feature on your end. Go ahead and type in a question. I'll be monitoring those, and as time allows, we'll be sure to get those answers for you. If not, we'll get those out to you in an email. If you have specific questions, you can also email Victor at businessperformanceusa.org, and he will get you the answers as well. So we welcome you to sign up at Business Performance USA and be a member. With that, Nancy, I'm going to go ahead and pass the screen over to you. So give me a minute, folks. We'll change presenters. And my goodness, there's quite a list here. Let's see where I'm going to change it over to Nancy, and just let me know.
Great. And we're going to put it into full mode. All right. Sorry about that, everyone. We had a little disappearance from the desktop somehow. So thank you for your patience. Well, and as I said, Cynthia, you're very gracious with your introduction. The one thing that I always tell myself and anyone that I'm working with, whether they're in my company or a friend, a colleague, a business networking partner, or somebody just seeking some good compliance advice, it's always about progress and not perfection. No company's ever going to be perfect. No organization's going to do it exactly right. But if you can constantly be making improvements and looking at how you're doing things and how you can make it better so that you're protecting your organization in an additional way. And really that's the history behind our getting into background screening and my getting into background screening in the first place. So with that, I hope that today, I'm remembering that we are still in the basic sessions of our webinar presentation, and we are doing a series of webinars over the next few months. But with this session, what we're going to be talking to you about is just a little bit more about the basic truths of background screening, and specifically a little bit to key you in on the governing laws in background screening. How do you want to think about choosing who is going to do your screening for you, and how you should design a lawful screening program. Now, each one of these subjects alone could be a comprehensive session, so we obviously are doing a little bit of an overview, but we are always here and happy to help out if anyone has any questions as a result of this webinar today. So the first question that I always suggest to anyone who's putting in a background screening program that they need to start asking is just, are they aware and do they know what the key federal laws are that govern background screening and would govern their program? The Fair Credit Reporting Act is really where background screening begins for any company who's engaging in using a third party to research, to collect, to disseminate, and put together a consumer report about an individual that they're going to put to use in their business setting. The Fair Credit Reporting Act, of course, by name indicates that it's all about credit reports. But that is the big myth with the Fair Credit Reporting Act, because in reality, the Fair Credit Reporting Act, as amended by the Fair and Accurate Credit Transactions Act, those two acts come together into one big body of law that we call the Fair Credit Reporting Act, or the FCRA. Under the FCRA, any kind of consumer report, which we'll talk in a minute about what that means, is governed by the Fair Credit Reporting Act. So it's not just the three major credit bureau reports, but it is, in fact, other kinds of consumer reports. And like I said, we'll talk about exactly what a consumer report is and is not. But I think we have to keep in mind whenever we're looking at a big body of law like this, who's in charge of enforcing it. And for all companies, all organizations across the country, whether you're a volunteer organization, a nonprofit organization, a for-profit organization, whether you're engaged in consumer lending, in providing housing or residential opportunities, or whether you're providing employment or you're engaged in consumer lending. No matter what type of business you might be in, the Federal Trade Commission, along with the Consumer Financial Protection Bureau, they work in collaboration now, are the two major federal agencies that are in charge of enforcing the Fair Credit Reporting Act. And I always think it's important to know what can happen if I violate that act. And there are large civil liabilities with damages, as well as government-imposed civil monetary penalties, and they're significant in dollar size. So in addition to just being liable in the courts when it comes to doing something that could injure a consumer, you also have exposure with our federal government. So I think it's a good body of law. If you're going to be doing a background check, you need to know or at least be familiar with your basic obligations under this law. So we'll talk a little bit about that today. Now, the original purpose of the Fair Credit Reporting Act is really designed to regulate users of consumer reports, and that includes both screening firms. We are providers of the consumer reports, and anyone who provides data to us is regulated by the Fair Credit Reporting Act, but also anyone we provide information about consumers to. So the Fair Credit Reporting Act would regulate users of consumer reports. Those are the employers, the landlords, the volunteer organizations, the licensing boards, membership organizations, lenders, and more. So at every part of the process in background screening, each of the organizations that are involved in that process, the organizations that furnish data, the organizations like ours, like Track One, who are engaged in background screening, and the organizations who are using the consumer reports are all three governed by the Fair Credit Reporting Act. So what qualifies as a consumer report under the FCRA? So in other words, what is a background check? That's sort of the layperson's terminology. The Fair Credit Reporting Act says that any written or oral communication that bears on a consumer's credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. So that's a really broad definition, and like I said, the Fair Credit Reporting Act doesn't just govern credit reports. It actually does govern things like criminal reports, driving records, reference checks, education records, drug testing, anything that's going to tell you some sort of information about a consumer. Some of the questions that we've had recently include whether the Fair Credit Reporting Act would govern, for example, a social media check. You know, I will say that by definition it would. We have not seen, to my knowledge to date, an actual FTC opinion letter asserting that in fact the FCRA governs social media checks, but that is a question that we get rather frequently. I'm going to see if we can, there we go. I apologize. I'm using someone else's computer, so it apparently had a setting in there. But the social media checks are one that are covered by the Fair Credit Reporting Act by definition, as you can tell, because looking into the social media would tell you about the character, the general reputation, and the personal characteristics, as well as the mode of living. So in addition to being a written or oral communication, it would have to be used or expected to be used or collected in whole or in part for some permissible purpose. And the permissible purposes are spelled out in the Fair Credit Reporting Act. Now, there are about 7 to 9 different Fair Credit Reporting Act permissible purposes. So permissible purposes for which you can use a consumer report. The specific ones that we generally talk about are for employment, for residential living, for government licensing, for consumer credit extensions. Those would be your typical permissible purposes. And of course, anytime a consumer authorized someone to run a consumer report on them. And as I said earlier, it is important to note that there are two kinds of consumer reports that are governed by the Fair Credit Reporting Act. One is the standard consumer report, and the other is what is called an investigative consumer report. Now, the difference is that an investigative consumer report really involves making calls out to get input in from other people about an individual. So reference checks, for example, would be a type of investigative consumer report. There are other types of investigative consumer reports that qualify, and there are slightly different rules that apply to those types of consumer reports. But in general, everything we talk about today would apply to both a consumer report as well as an investigative consumer report. And I think the key thing really for all organizations to understand is that your typical background screening report that you go out and order from a third party, someone outside of your company, even though it doesn't contain credit information, still is a form of consumer report. And not only are you governed by the Fair Credit Reporting Act, but the person that you get that report from is governed by the Fair Credit Reporting Act as well. Now, I'm asked oftentimes, why would that matter? So many organizations that we talk to on a day-to-day basis will say, well, my friend down the road used to work for the police department, and so I just call him up, and he's able to call his buddy down at the sheriff's station and look up at some information for me, and he shoots over a little report to me, and that's how I run my background checks. Well, that is the exact kind of an example that this body of law is trying to take control of, and without even realizing it, the organizations that are going about doing it that way are oftentimes very much in violation of these laws. So it is important to understand that and understand what your obligations are as an organization that's using consumer reports to do background checks on consumers. So other laws that you definitely want to be thinking about if you are establishing a background screening program at your organization, there are numerous laws, but I tried to pick some of the big topics, the large federal laws, and then also just kind of reference some of the state-specific laws. So the Driver Protection Privacy Act, if you're doing any sort of driving records or checking into the driving history of someone, you would want to be familiar with and look into the Driver Protection Privacy Act. There are a few programs out there that deal with volunteers, and specifically volunteers who work with children. The National Child Protection Act was the original law. It was then amended by the Volunteers for Children Act of 1998, and then in more recent years, a pilot program was put together under the PROTECT Act, and each of those laws have to do with granting access to certain kinds of child-centered daycare and youth-serving organization facilities, and giving them direct access into the FBI's data. Now, there are or the state-specific data. Those laws all talk really more about access mostly, and having a right of access, but I think it's really important to note that the FBI's database, while it definitely has a large amount of information in it by the FBI's own admission, is only about 60 to 70% correct. And we've even heard more recently from representatives of the federal government that number may be down in the 55 to 60 range. So it's kind of a floating number. So I'm really cautious about quoting a number out there, but there is some inaccuracy. There's some incompletion in that database. I've always viewed those national criminal searches of that nature, or any nature really, to be like a large net that you cast over the whole country, and it has a lot of holes in that net. There's a lot of information missing. There's places that don't report their information in, or they don't report it timely. But it is a large net, and you can cast it over a broad array of geographical region. But that's not the only thing that you want to do if you want to really protect your children or your organization or your mission. So, I've always been an advocate for doing more than just the FBI data search, or more than just a multi-state criminal history. So in addition to that body of law, which really relates to volunteer organizations, if you are a landlord or a property manager, anyone who's involved in providing housing, and you're doing background screening on the residents that are applying to live in that housing, the Fair Housing Act is something that you're going to want to look at. And in particular right now, I think you need to have your eye out for a United States Supreme Court case that is under consideration right now. I think they're in the briefing stages. Our organization was pleased to be able to contribute to that, to an amicus brief that was filed by the National Association for Professional Background Screeners in conjunction with that United States Supreme Court case. And the name of it is called Mount Holly. And in short, the United States Supreme Court is going to be looking at a number of things. One of the issues that they're going to be addressing or considering and hopefully ruling on, is whether or not a claim of disparate impact can be made under the Fair Housing Act. So it's an important case to watch, and like I said, we're expecting to have briefing finished this fall, and arguments are being made this fall, and ultimately a decision should be issued sometime before they take a break for the holidays. Then finally, another big bank of laws that you'll want to look at if you're implementing any kind of a background screening program would be the state-specific laws. Some states have specific laws that are actually titled as background screening. They sometimes come along with the title of consumer reporting laws, private investigation laws, privacy laws. There are a number of different words associated with those various state-specific laws, but knowing those laws or being familiar with those laws is also important. Now, what you don't see on this screen is one more area that I'll suggest, and that is each industry oftentimes has specific regulations that mandate certain kinds of background screening or background checks. So being familiar with that can also be helpful. So how do users of consumer reports go about satisfying their FCRA obligations? So if you're an organization and you're putting into place a background screening program, the question is, how would you make sure that you were actually going to be in satisfaction of the Fair Credit Reporting Act? So there are a few things that, as an organization who's putting in a background screening program, you want to make sure that you do. First of all, the users of consumer reports want to make sure that they're choosing a quality screening provider and that they have a permissible purpose for conducting those background checks or obtaining a consumer report. The second thing that you're going to want to make sure that you do is you want to make sure that you're using a proper consumer disclosure and authorization form. And third would be that you design a proper adverse action with notice as required. And finally, you definitely want to have a written policy and procedure that satisfies all the elements of the legal criteria. And as a part of that policy and procedure, and we'll talk about this towards the end of our webinar today, you want to make sure that you've addressed and considered what you're doing in relationship to access of information about consumer reports, destruction of any records relating to consumer reports, storage of those records, etc. So those are the main four things that you definitely want to make sure that you are addressing as you are establishing your program to ensure that you're in compliance with the Fair Credit Reporting Act. So the first thing we'll talk about is just the issue of how do I go about choosing who is going to help me conduct a background check for my organization. Well, there are a lot of choices out there. Like I said, I hear a lot of people talk about the friend down the street who knew somebody who used to be a sheriff or is a volunteer in the sheriff's department. I certainly can't advocate that avenue for a number of reasons. Most of the sheriff's departments obviously would restrict the use of their data, but also, you would be a violation of the Fair Credit Reporting Act in going about it that way. So there are organizations out there that are members of a national professional group called the National Association of Professional Background Screeners. I've been a proud member now for about 6 years, actually almost 7, I think. And the organization has been around for about 10 years. So remembering that background screening used to be a very manual process, and it's only in the last 15 or so years that computers and data and internet and databasing has become so prolific that we're able to really digitally transmit, digitally organize, digitally report, and do a lot of other things in a secure enough way that background screening has become, like many other things in our world today, very online, very digital. So the National Association of Professional Background Screeners was formed now 10 years ago. And the members of that organization certainly would be kind of that making sure that a company you're working with is a member of that group would definitely be a step one in looking at who you're going to be engaging. Now, I will add to that there is another group called the National the Consumer Reporting Agency, NCRA. They also have a strong membership base. It's slightly different membership base, but also a national organization. And between those two organizations, if your organization that you're looking at using is a member of one or both of those, you probably are going to be in a good place working with a company that at least is knowledgeable in the Fair Credit Reporting Act. I think the second thing that you should look at is, are they accredited? Now, the NAPBS has come out with its first round of accreditation, and it is designed for domestic screening, employment screening only. So if you are looking at using somebody to do screening for you, background screening of your employees or your volunteers, then making sure or considering working with an accredited member might be something that would be of great value. We're seeing that accreditation become more and more standard. And it is, while it's not a guarantee that an organization is perfect, what it is an indicator of is that they have put into place the policies, the procedures, the practices, the systems to ensure that they are delivering secure and compliant screening. The second or third thing that you would want to consider is, what about their staff? How trained are they? The NAPBS as well as the NCRA have certification programs which allow for people for a very nominal fee. It ranges from $30 to $70 depending on which organization and which certification they're getting. But they can get certified online to establish that they've been trained and passed an exam, to establish that they are familiar with the Fair Credit Reporting Act and its requirements. So knowing that you're working with a group of people that have that kind of FCRA certification is important. I would add to that you want to make sure it's not just the sales staff that is FCRA certified, but it's everybody in the organization who has gone out and sought that kind of certification and has really dedicated to learning what the requirements are for the clients that they serve. I think another element that you want to definitely evaluate is whether they're recognized and known as a service provider who's looking to implement screening best practices, to customize your product mixes and your options, that are familiar with federal and state compliance and laws and changes to those laws. A company that is very familiar with and is actually in charge of their own databases, their matching technology, their compliance filters. A lot of organizations are really just sales offices, and they're selling other people's databases, other people's platforms, they're leasing them. So knowing how much control the group that you choose has over the platform that they use, how much control they have over the data, and how much intimate awareness they have with what's going on with that data delivery. Additionally, you want to make sure that it's an organization that is experienced in and has knowledge in, obviously, courthouse records research and research in general, consumer research and consumer reporting. And finally, that has the capability of software integrations and high experience in the technology field. So if you're looking at criteria, again, being familiar with the background screening company that you're looking at, knowing that they have those kinds of features and abilities is very important. I mentioned earlier that the owning and operating of your own platform, your own technology, product, and data can become very important in that analysis. Again, just for the purpose of being able to control the data. When you do have an issue, they have immediate access to the information in its raw mode, and they can evaluate the accuracy, and they can evaluate and research and resolve consumer disputes in a more rapid way. So I think that's an important feature as well. And finally, a company that's able to deliver the multiple screening types that your organization may be interested in. All right, excuse me. So next up, once you've identified the first part, which is who's going to be doing your background screening for you, the next thing that you want to think about is, do you have a permissible purpose? And does that permissible purpose allow the company to furnish to you a consumer report? So as you may recall, I indicated that the Fair Credit Reporting Act actually spells out several different permissible purposes, and I've listed some of those down at the bottom there. But in short, one of the questions we get a lot is, would the Fair Credit Reporting Act govern volunteers? Because volunteers aren't paid, so they're not really employees. Well, in fact, we do know that both volunteers as well as contractors, so independent contractors, and even agents, sales agents, for example, if you're commission only or not fully employed as a W-2 employee, any of those kinds of individuals are in fact governed by the Fair Credit Reporting Act. The FTC issued an opinion letter as recently as 2011. Others had been issued prior to that, but that one certainly put to rest all questions that had ever been out there about that issue. So in establishing your permissible purpose, one of the things that can establish permissible purpose is if a consumer instructs somebody in writing to give you a consumer report. Now, we're going to talk a little bit later about a disclosure and authorization form where a consumer actually signs a form and says you are allowed to have this. And that certainly does satisfy the criteria of having a permissible purpose under the Fair Credit Reporting Act, but there are in fact additional ways to go about getting a background check on a consumer. In response to a valid subpoena or court order would be another way that somebody might have the right to obtain a background check. And finally, you are allowed, a background screening company is allowed to issue a background check to a person that we have reason to believe intends to use it for one of those legitimate purposes down there. So those are some of the other areas besides the employment purposes, besides the residential screening purposes, which we talked about on the previous page. So there are clearly a number of permissible purposes under the Fair Credit Reporting Act. I think the vast majority of people who are logged into this webinar today are really using it for employment, for volunteer, for residential screening and or licensing or membership type purposes. So the third thing that you need to do as an organization who's putting into place a background screening program, once you've identified who's going to be doing your screening for you, and once you've identified and confirmed that you've got a permissible purpose and have certified to that, then the next step is making sure that you have a proper disclosure and authorization form. Now, the purpose of the disclosure and authorization form is where you are going to be disclosing to the individual who's applying for the position or for the residency or for the housing. You're disclosing to them that you are going to be running a background check on them. You need to disclose in a certain way and certain things, which we're going to talk about. And then in exchange, they are going to, in writing, authorize you to actually go out and get that background check on them and put it to use. So it is a one document form called a disclosure and authorization. Now the Fair Credit Reporting Act specifically says two things in particular that are of importance. The first thing is that disclosure and authorization needs to be clear and conspicuous, and it needs to be in writing. Now obviously that means it's legible. If you are a volunteer organization that works particularly with the elderly, it might not be clear and conspicuous. If you have it in 10-point font, you might want to consider putting it into a 14 or a 16-point font, which is a little bit more legible for your client base that would be applying. So clear and conspicuous might be defined in different ways depending on who you're serving, who your consumer base is. But at any rate, it needs to be clearly written, clearly understandable, not purely legal language, simple to read, and able to be understood by the people that you would be providing it to. The second one thing that should be discussed is that there is an FTC opinion letter out there that specifically says the disclosure and the authorization form can be in one document together. Now, I emphasize that because there is also an opinion letter out there that says that it needs to be in a standalone and separate document, meaning separate from the actual application form. So there's been confusion on occasion about the different things that those two opinion letters are saying. So the idea is that your disclosure and authorization form should be on one piece of paper. That piece of paper should be separate from the actual application. That's how that works. Then the next thing that the Fair Credit Reporting Act talks about is that you want to make sure that your written disclosure and authorization form that you present to the consumer is actually signed by the consumer before you ever go to order the consumer report. That might seem obvious, but particularly in this world of electronic systems, things can happen in an electronic and automated way in the wrong order. So it's important to understand that that is a specific requirement in the Fair Credit Reporting Act. And finally, you need to specify in that disclosure and authorization whether you want that exactly specifically what is going to be covered by that. So as you're putting together your background screening program, you would want to specify what kind of things you're going to be checking for, whether you have the authority, whether they're granting you the authority to run checks on them throughout their employment or throughout their tenancy or throughout their volunteer service. So these kinds of specifics need to be included in your disclosure and authorization form. Additionally, I think it's important to note that there are a number of states that have issued very specific rules about how those disclosure and authorization forms should read, or specific language, sometimes even language that's contained in a box and has a checkmark box in it. Oklahoma is an example of one of those states. So you want to make sure that whatever firm you're working with, whatever background screening firm you're working with, they're able to provide to you a 50-state compliant sample disclosure and authorization form that addresses all of these things. So the next thing that you want to do as a part of developing your program is to make sure you design a proper adverse action process. Now, that sounds so legal and complicated. In essence, what that means is if you're going to run a background check on somebody, and if you find out information, and as a result of that information, you are thinking about not hiring the person, or not promoting the person, or not allowing them to live on your property, or not granting them privileges, or not granting them access or right of membership. So if you're going to take any sort of adverse action against that person based on the information that you are obtaining as a part of that background check, then it's going to be important for you to understand that there are specific rules in the Fair Credit Reporting Act that talk about how to give proper adverse action notices. In the employment and volunteer setting, there are actually two notices that have to be provided. One before the adverse action decision is made, and another notice after the adverse action is made, adverse action decision is made. Now, in the other types of screening areas, so if you're screening for a residential facility or you're screening for a membership organization, then in those situations you only provide one notice, and that is the post-adverse action notice. Let's talk a little bit about what's required in each of those adverse action notices. In the pre-adverse action notice, you're going to be providing the individual notice that you have obtained information from a background screening firm, and that in fact there's information that has been provided which may result in an adverse action or a decision not to hire or a decision not to promote or a decision not to allow them come onto your property. So as a result of that, you are going to, as a part of that notice, you're going to provide a copy of the actual background check that you got to the individual. You're going to provide them with a copy of the FCRA Summary of Rights, and that document can be found on the Federal Trade Commission's website. Additionally, most of the background screening providers can provide you a copy of that. It's actually written by our federal government, so we don't give any input into how that form looks. But that summary of rights will tell the consumer what their rights are under the Fair Credit Reporting Act. And finally, you're going to tell that individual how they can go about filing a dispute with you about that report. So 3 things that you want to keep in mind in that pre-adverse action notice. You have an obligation to let that individual know, hey, I found out some information that's causing me to question whether I'm going to give you this right or give you a job or give you a place to live. And as a result of that, I'm telling you this information, I'm giving you a copy of this. And if you want to call into question my decision or this report that I got, get a hold of me within the next X number of days. Now, typically we would recommend at least giving that consumer 5 days. There may be reasons in your particular area where 7 days or more is appropriate and required. So you'll just have to look into what's a reasonable amount of time to give them to dispute that report. Now, I will say that the next thing that should happen is that consumer should have that chance to dispute the report with you. And as a part of that dispute process, that really is a conversation. They should be able to say, this information is not me, it's somebody else, or they should be able to dispute that you have old information that hasn't been correctly updated. Now, the fact that they've disputed information doesn't mean that your background screening company has failed you. It just means that that is exactly what the dispute process is designed to do. That's what the Fair Credit Reporting Act is designed to do. We all understand that electronic courthouse records, electronic data, data-based information can and will have missing information, mismatches. It happens with our credit records. It happens in lots of different arenas. So this body of law is designed to protect individuals as well as companies when that happens. So the dispute process puts the burden on the individual to let the company know, hey, something's not right about this report. Then it puts the burden on the company to talk to that individual about what's not right and to do some research in conjunction with the screening firm that they use. Now, remembering that I talked to you earlier about looking at the criteria for your background screening company, one really important criteria is that you want to make sure you're working with a screening firm that has experience with dispute resolution, that has a strong record of resolving those disputes rapidly, timely, and to the satisfaction of consumers. So really getting to know your background screening company, getting to understand their dispute process, how they handle things, and their record of dispute resolution is important. So once you've given the pre-adverse action notice, then you've had the conversation with the individual, giving them a chance to dispute the results of that report. Let's say that they're not able to dispute it, then the next step is you would provide a post-adverse action notice. And what that means is you've made the decision that in fact, that it appears that the information on this report is correct. When you did your research, you weren't able to find any information to the contrary, or the information contained on there that wasn't disputed disqualifies the individual. For whatever reason, you've made the decision not to hire, not to allow them onto your property, not to allow them to have a membership, not to allow them to serve in your organization. And as a result of that decision, then you would be issuing to them an adverse action notice. Now, this adverse action notice is called the post-adverse action notice, and it is a little bit more detailed than the pre-adverse action notice. In this one, you actually need to provide the name of the background screening company that gave you the information in the report. You need to let them know what your actual decision was as a company, and you need to let them make a statement in that adverse action notice that the screening company did not make the decision, but the screening company did provide the information that was contained on the report. That way the individual understands the role of both the company that made the decision and the company that provided the information on the report. You should also provide them with that summary of rights, which will spell out their rights to dispute within 60 days that information on the report, and it will also spell out their rights to get one free annual copy of their report from any national screening company. So again, in designing that adverse action process, 2 keys and kind of insider tips is making sure you have a quality conversation with the consumer between those notices or before you issue that post-adverse action notice. Making sure that you take time to review with your screening provider and to give your screening provider adequate opportunity to research those disputed items on that report. And then also that you take time to really individually assess the information contained on the report relative to what you're trying to decide to grant to this individual. Now, the individualized assessment concept has really been spelled out in the employment area. So if you're looking to hire somebody and you obtain a background screening report on them that has adverse information about the individual, making sure that that adverse information really is relevant to the position that the person is being considered for, and it's got to be relevant in time, it's got to be relevant to the position, and it's got to have some statistics and some documented proof as to why you believe that information is an indicator that they are not eligible for the position in question. So we've really seen some stepped up procedures required in the employment screening area, in the area of individualized assessment, but really the individualized assessment has always been about making a reasonable decision. And that standard really would apply in any of the decisions that you're making in the other types of background screening you may be doing. The other insider's tip that you should have heard from this is you definitely want to make sure you're working with a screening firm that has a quality to dispute process in place. And you know, one of the first things that I've always said, and what I always say to our employees when you're working on a consumer dispute or any kind of question about a report, is that this is our #1 risk management tool. This is one way that we serve our clients, and if we can fix the information or fix the report or answer the questions or even help the consumer figure out how to resolve it for themselves, if it's not something we have the authority to do for them, but if we help walk them through that process, we're going to have a happy consumer. We're going to have a client that's happy because they aren't going to have a consumer that's upset with them or with us. So we really view that process as a part of our brand and about a part of our service mindset. It has to really be alive in that process. So again, knowing what your screening firm's perspective is on that dispute process is really important. So the final step in establishing your background screening program is making sure that you have a written comprehensive policy and procedure. And this has become particularly important in the employment screening arena, but it's equally important in the other areas as well. So that policy and procedure really needs to specify what the overall goals of your background screening program are, who oversees that program, and what the levels of decision-making authority are. Additionally, that program should talk about the scope of the background screening program. So does it only cover employees? Does it also cover volunteers, contractors, visitors to your organization. And additionally, as to scope, you should also discuss in there what kind of background screening you're going to be doing, and the timing and the frequency of your screening. So are you doing it annually and updating your information annually? Are you doing it every 6 months? And there are different regulatory requirements as well as different standards for different industries. So as you're working with a background screening firm, they should be able to give you some insights into what those standards are. So the other thing that an additional item that your written policy and procedure needs to address is, what is your decision-making criteria? So for example, if you run across an individual, if you're looking to hire someone in your accounting department, and the only thing that they are doing is administrative, they're boxing up files, they are making copies of paper, but they don't have access to financial records or financial bank accounts or financial information, then that would not be a position that you would want to look at credit reports on. But if you're looking at hiring someone for your accounting function, and they're going to have access to your financial bank accounts or access to cash or access to your records, then a credit report may be very appropriate. So what are the decision-making criteria for the particular position that you're considering hiring for, or for the particular type of unit that you are putting somebody in to live? And what are the acceptable standards for residents in that facility? So whatever those decision-making criteria, they need to be spelled out. And then, of course, the discretionary protocol. When you do have an issue come up that's not black and white, that's not clear, who, how, what, and when will they make a decision? And spelling that out in that policy and procedure has become very important. Having that documented, as well as having the job-specific criteria that we discussed for the individualized assessment documented, is going to be important. Next, you obviously want to make sure that you address record retention, destruction, storage, and release. We'll talk about that a little bit more in the next slide. But all of that should be documented as a part of your written policy and procedure. And finally, you want to make sure that your adverse action and dispute processes are spelled out, as well as your commitment to individualized assessment and how you make that process work in the context of your particular type of screening. So when it comes to the record retention, access, and destruction portion of your written policy, procedure, and your practices, there are a few things I want to highlight. As far as access to your background screening records, today most of the background screening companies that you're working with are online. They almost all have some sort of a unique credential. And these are the kind of secure systems that you want to make sure you have in place in connection with a background screening firm that you would use, as well as in connection with the records and the ways in which you store the records if you print them off and store them in your facility. Now, if you're storing them digitally, the same rules would apply. A lot of companies rely on those background screening reports to be retained by the background screening company, and while that certainly is acceptable, I would always recommend that you download those to something that you have control over, but then password protect, secure, and process that download according to standard record retention and destruction protocols. So back to the access to the records, you want to make sure that every individual user has unique credentials. Most screening firms do not charge for different users to be able to use their systems, and it's really important that you don't let one user log in using another user's credentials. The other thing is that you want to make sure that you change and update those credentials at least every 6 months, if not more often. And you want to make sure that there's some sort of administrator who has control over the level of access for each user that has access to the background screening information and records. And then you want to make sure that you shut off access whenever staff changes occur. These features are a part of just protecting the consumer privacy, obviously, as well as the company records. Next, you also want to consider retention policies. Most companies will retain their records for somewhere in the 5 to 10 years. Now, I will say that if, for example, you're working in a highly regulated industry, there may be a federal government regulation that specifies that you need to keep those records longer. Schools may have a state law that requires them to keep those records longer, although most of those state laws fall somewhere in that 5 to 10 year range. Additionally, I think that most of the state level record retention policies, I have not seen a 12-year policy at this point unless it was in a specific industry. So you should be safe if you're preserving your records according to whatever your federal and state regulations are in your general business record retention, if you stick with that 5 to 10 years. When you dispose of the records, there's specific language in the Fair Credit Reporting Act that talks about you want to make sure that you burn, pulverize, or shred papers, destroy or erase electronic files or media so that information cannot be read or reconstructed. That's one area. A lot of hard drives are put back in a storage bin for a technology department, but they're never stripped of the information. So you want to make sure that your organization is exercising those kinds of practices so that information is not left on a media device. Of course, today we're also running into issues not only with electronic files or paper files, but with what we call mobile files, whether you're using a thumb drive, a Dropbox, which is a cloud-based computing file, but they're all forms of being able to access information when you're on the go. So being prepared and having written out a documented policy for how to deal with information that may have been stored in those ways as well is going to be important. And finally, you want to address the release of the record retention or destruction, and that would be generally limited to the Fair Credit Reporting Act permissible purposes. So you would only be able to release the information for those permissible purposes spelled out in the Fair Credit Reporting Act, as we discussed earlier. All right, so the key takeaway points today that I hope you've heard from this second in our series are on the basics of background screening would be that you know the key governing laws that are going to govern your background screening practices, that you familiarize yourself with your Fair Credit Reporting Act obligations, that you choose a reputable NAPBS accredited firm or NCRA accredited firm, that you establish a documented and lawful policy and procedure and process, that you actually implement that process appropriate to that policy and procedure, and that as a part of that process you are following proper record retention and disposal requirements. And I think if you can do these things, a successful landing will result from your planning, as you can see from our little photo shot. So I hope that you find this basics information helpful today. And Cynthia, do we have any questions?
We do, but we have run out of time. So what I'll do, Nancy, is I'll be sure to get that question to you, and we'll send the answer to the person that asked it. And with that, if you'll go ahead and scroll to the next slide, we'll go ahead and wrap up since it's just past 2. If you have more questions, please check out the full webinar series at track1.com. Business and also businessperformanceusa.org. Next, Nancy will be up in November with the third part of the basics of background screening. And you can contact Track 1 directly. You can write this down, track-1.com, 1-800-600-8999. And Nancy, if you'll scroll forward, we'll just tell them about what's coming up. We have 3 webinars planned that are coming up on marketing, on change implementation, and on problem solving. So you want to stay tuned for that. Again, go to businessperformanceusa.org and become a member, and you can view the webinars from today as well as prior webinars, and all future webinars will be recorded. We thank you today for your time. Everybody's been very attentive and excellent information, Nancy. It's very clear that you need an expert such as yourself helping you guide you through the waters of background screening. So with that, folks, I'm going to end the webinar. Thanks so much. Join us next week. Bye, everyone.